sick. Alhamdulillah. The whole family's sick. So, yes. They love to show love and share everything, including the sickness. Inshallah. Assalamu alaikum. Thank you, Ma. Alhamdulillah. I have it. Okay, let's begin. Bismillah, alhamdulillah, wa salatu wa salamu ala rasulillah. The disagreement among spouses over the dower. So if the husband and wife, after getting married, they disagree about what was agreed upon in terms of the mahr, or the gift that the husband has to give the wife, what happens? So it says their disagreement may be either about the possession, meaning did you actually pay me my mahr or you didn't, the amount, the category, what type of thing did we agree upon, or the time, that is the time of obligation, when you have to pay. So if they differ, husband and wife, if they differ about the amount of what the mahr was supposed to be, with the women saying, for example, it was 200, so let's say $200, and the husband saying that it was 100, he's trying to get a discount, the jurists disagree extensively about this case. Now, let me just point out that this is more of a juridical type case. So this is what Muslim scholars also have to deal with, not only theoretical cases, but real cases. So if somebody comes to you, and this happens, somebody comes to you and says, look, you know what, he promised me the mahr was supposed to be 2,000, and he's claiming that it's 1,000. And we already got the nikah done, marriage is done and everything, and now I want my 2,000. And he's saying, no, I said 1,000. You misunderstood me. Or your one looked like a two or whatever it was. So what do you do in this case? Oh yeah, it happens. Oh yeah. In fact, recently we had one, it was a very large amount and a world of difference between the two statements, and they ended up going to court. And the sheikh who actually did their marriage had to go in court and testify. And after that, he called all the imams and says, look, man, for your own benefit, always write down what they told you. Just for your own knowledge, because we do hundreds of marriages, you're not going to remember what they agreed upon. So if they don't write it down, even you write it down for yourself. So what we do is we make sure, my advice to everyone is, they should at minimum get the mahr notarized by notary public. And that's the minimum. And higher than that, it should actually be done officially, where it's like a, what do they call it, promissory note or whatever it is. When you get a loan from somebody, it's binding by the government. You have to pay this off. That's what mahr is supposed to be. It is a contract. Yes, it is a contract. And you want it to be binding. So what happens in this case? How do you deal with the case? Well, you can't go to like Judge Judy or something like that, because that's what she'd deal with, right? So Muslim scholars have to deal with this as well. So what we want to know is, if a Muslim scholar is dealing with a case like this, what is there in Islam that guides them to what the correct ruling on this case would be? So he says, jurists disagree extensively about this case. Why? Because this is a case which is more in the realm of juridical proceedings, right? So it's one person's word against the other person's word. It's not just about how to interpret Islamic texts. Part of it is that, and part of it is something else. There's going to be a lot of reasoning involved here. So Imam Malik said, if the disagreement arises prior to seclusion, okay, what does seclusion mean? That after they were married, doesn't mean that they've been alone in a room together. So he says, Imam Malik says, if they're fighting over the dowry prior to them being alone, but the marriage contract has already taken place, and both the bride and the bridegroom are making credible claims. They're not making outrageous claims. So the woman is not saying, he promised me, 5 million or something like that. And the guy's saying, no, I promised her 5,000. This is something way out there. Then both are to be asked to take oaths and revoke the contract. So Imam Malik says if this is the case, prior to being in seclusion, because seclusion could mean that they were intimate together. Regardless of whether they are or they're not, it makes a difference. So Imam Malik says both of them have to swear by Allah that this is exactly what they know to be the mahr. If both of them swear and they're differing, one is saying 1,000, one is saying 2,000, the contract is revoked. It's not divorce, but the marriage is nullified. The marriage is cancelled completely. So they're not married anymore, but it was not a talaq, it's not a divorce, it's not a khula, it's not remission from the wife, it's called fasakh. The marriage contract is finished. Because you know what? If they haven't even been alone together in a room, if they're going to fight over mahr, they shouldn't even be married. Marriage contract is gone. It's finished. It's the best thing to get rid of that from the beginning. So their marriage is finished. If one of them takes the oath and the other one refuses, then the statement of the one who takes the oath will be accepted. Now, this is something that happens. Don't think it's like some random case. There are people who, they insist that, no, I know I'm right, but then when you put them on the spot, say, do you swear by Allah? Do you have that much confidence? They have a little bit of taqwa and they'll stop and they'll say, no, I'm not willing to swear by Allah, because they know that even though they're saying I'm 100% confident, they still have a little bit of doubt and hesitation. So they say, no, I'm not that confident about it. Right? So if one of them takes the oath and the other one doesn't, then whoever took the oath, that's the one who's going to be accepted. Okay? The one whose oath will be accepted. If both of them refuse, okay, so what if both of them say no, we're not going to swear by Allah. Both of them refuse to take an oath, then it will be considered as if both of them had taken the oath, and the statement appearing more likely will be accepted. So the judge then will rule whichever one seems to be more likely, the judge will decide. And they're going to go ahead and take that in that case, and they have to settle according to that. So the marriage will not be nullified if they both refuse to take an oath. If the dispute arises after seclusion, so now they're married and they've been alone in a room together, whether or not they actually had intimacy or not, that's not the point. They've been alone together such that they could have had intimacy. The acceptable statement will be the husband's statement, according to Imam Malik. But a group of jurists said that the acceptable statement will be the husband's along with his oath. So it's not only the husband's statement, but he has to actually swear an oath that this was the real amount, and then we're going to go ahead and take the husband's statement. Now the question is, why take the husband's statement? We want to understand certain things, right? So we try to figure it out. It's going to explain anyway, so let's not spend too much time figuring it out. Well, what would your guess be? Why take the husband's statement after seclusion, but before seclusion, we have to do the whole swearing of oaths and everything? What's the difference between after seclusion and why the husband's statement? Okay, maybe because he's the head of the family, has to make a final decision, potentially. I don't think that's a strong. It's a good guess, though. It's a good guess. That has more to do with, right? So she's allowing him, right, to actually do this before even looking in and investigating, and they've already had an issue going on or whatever it was. You don't know if the dispute took place before or after. Assuming that the dispute took place before, and then she allowed him to be, in private with him, becomes an issue. So that's part of it. That's part of the reason. All right. Any other guesses? That's mostly it. But then we're going to talk about a third part. So, this was the opinion of Abu Thawr ibn Abi Layla. So Abu Thawr, he's an independent jurist. He had his own school of thought. He's considered a mujtahid. Ibn Abi Layla also had his own school of thought, considered mujtahid. Ibn Shubrama, as far as I recall, he's a student of Imam Malik in that line. So he's not like that big of a scholar, actually. But they just threw him in there anyways. And a group of other jurists, so some other scholars as well. Another group of jurists said that the acceptable statement will be that of the wife to the extent of the mahr al-mithl, and that of the husband to the extent of the excess over the mahr al-mithl. Does anyone remember what the mahr al-mithl is? The what one? Exactly. So the people around you, according to your custom, what mahr were they getting? That's known as the mahr al-mithl. So another group of jurists outside of Malik and this group here, they said that the wife will actually, even after seclusion, the wife will get her statement will count as long as it's up to the extent of what women generally get. So if women in a community of that status get 5,000, if she claims 4,000, she will get it. And he's saying 3,000, we go ahead and we give it to her because she's not asking for something above and beyond. But it'll be that of the husband to the extent of the excess over the mahr al-mithl. So if she's claiming a higher amount than that, then it's not going to be her word, it's going to go to the husband. A third group of jurists makes them take oaths in case of dispute and makes them revert to the mahr al-mithl without rescinding the contract, unlike Malik's opinion. So there's another group that says, you know what, regardless of all of this, what's happening, they will take oaths if they're fighting about it, and they will automatically go back to the customary mahr that's supposed to be there, regardless of what the two are claiming. So it's neither of what they claim. What they claim is both cancelled, and we're going to go ahead and give the woman whatever is customary, and the contract will not be broken. They will remain married. And so this is the opposite. So Imam Malik says if you can't agree, you shouldn't be married. Marriage is cancelled. This other opinion says, you know what? If you can't agree, you're both stuck with each other, and you're going to get what everyone else gets. And now just continue with the marriage. So complete opposite opinions. Yusuf. They're not going to take what into consideration? Yeah. Making them take the oath? Just in case one of them refuses, then you won't get into this category. So you force them to take an oath. If one of them refuses, then the other guy is automatically right. Or the other person is automatically right. They still stay together, and she's going to get mahr al-mithl. Okay, that's that's actually coming, okay? But we're not talking about adultery here. We're talking about money. In adultery, so this is interesting. Ibn Rushd is going to talk about this. He's going to say some people make analogy upon adultery, and he's going to talk about whether he agrees if that's a good analogy or not. But it's good you've read ahead to that part. Because so there's a difference. So if you accuse your wife of cheating or your husband of cheating on you, that's different than if you accuse them of ripping you off for $50. So this is different, right? So there's a big difference. It's definitely not a good start of marriage. But what do you do in this case, right? And keep in mind, this is more like, traditional. Once you've been married, right, and then the marriage has been broken, still, some people would want to continue, or maybe they're just being childish, they're still immature. So should they break up the marriage just because of this, or should the judge come in and I'm going to sort this out? I'll figure this whole thing out for you. Right? That's kind of what it is. So mahr al-mithl without rescinding the contract. This is the opinion of Imam al-Shafi'i, al-Thawri, and another group of scholars. So Imam Shafi'i's opinion is that marriage is not broken. Imam Malik's opinion is they both swear marriage is cancelled. It is also said that she is made to have recourse to mahr al-mithl without taking an oath, as long as the sadaq al-mithl, sadaq and mahr are synonyms. So as long as the sadaq al-mithl is not more than what she's claiming or less than what he's asserting. So again, Ibn Rushd just throws in another opinion. So there's actually another opinion, and he just throws it in like a footnote type thing here. So we'll skip. Both of which ones? Yeah, they're synonyms. So why does he use the word sadaq and then use the word mahr? Either he got bored of using the same word, or these are his notes. The sentence? No, he's saying it's the same thing. So he's saying she's made to have recourse to mahr al-mithl without taking an oath, as long as the mahr al-mithl is not more than what she's claiming. It's the same thing. So it's saying that this is what's going to happen as long as this is not more than what she's claiming. So the sentence itself makes sense. Yeah, makes sense. Okay, is that clear on the? You just read the sentence again afterwards, and then just read Mahr al-Mithul both times. I think it'll make sense, inshallah. Yeah, just change it to it, exactly. As long as it is not more. That'll clarify, inshallah. Question? No? Okay. Alright, so their disagreement is based upon their differing understanding. So their meaning the scholars. They have a different understanding of the words of the Prophet ﷺ, that the burden of testimony is upon the plaintiff, while the one who denies is to take the oath. Okay, so this is a hadith. It's an authentic hadith. It's a very famous hadith and terminology in terms of making judgments. Al-bayyinatu ala al-mudda'i wal-yaminu ala man ankar, or wal-yaminu ala al-mudda'a alayh. So basically, the burden of testimony is on the plaintiff. So who is the plaintiff? What is the plaintiff in a case? The one who's is it the one who's making the claim or the one who's defending against it? Making the claim. So the plaintiff is the one who's making an accusation or a claim, and the opposite is the defendant. So you have, or contesting. Yeah, contesting. So you have a plaintiff and you have a defendant. So here, the mudda'i or the plaintiff, the Prophet ﷺ said, the burden of testimony is on the plaintiff. Right? He's got to bring some proof, some evidence, while the one who's denying it, right, is to take the oath, meaning the oath is upon that person. So for example, imagine I take this laptop home, okay, and I'm claiming this is my laptop. So I say, this is my laptop, and then Brother Samar comes, and he says, no, this laptop belongs to the masjid, right? And I say, it's in my home. It's in my house, it's in my bag. You came into my house, and you're claiming this is your laptop, this is my laptop. So who is the plaintiff, and who is the defendant? I'm the defendant, exactly. He's the plaintiff because it's in my possession. It's in my house. If it's not in my house, it's different, right? But it's in my possession, it's in my car, it's in my house. It looks like it belongs to me. So this person is claiming, no, it actually belongs to the masjid. It's in the wrong place. So what happens? Who needs to bring proof? He needs to bring proof because it's already in my house. My proof is it's right here. This is my home, right? So he needs to bring proof to show that this is, belonging to the masjid or whatever. And I have to take the oath after that. Huh? I have to take the oath. Yeah, exactly. So this is what the hadith is saying. So now, the reason why they differ is, does this hadith have an underlying rational reason or not? Does it have an underlying rational reason or no? Those who maintain that it does have an underlying reason said that the one who has a stronger prima facie claim is to take the oath always. But if their claims are equal in strength, then they are both to take the oath and the contract is rescinded. Let's look at the sentence again. Those who maintain that it has an underlying reason. There was a reason why the Prophet ﷺ said this. He didn't want you to just follow it blindly, literally. But there's a reason why he said it in a certain context. They said that the one who has a stronger prima facie claim. What is a prima facie claim? You looked it up, huh? Good, mashallah. Prima facie means as it appears at first sight, at face value. And how do you pronounce this? Because I said it that way, or you knew that? Prima facie. Right. Actually, there's 3 ways to pronounce it. Right. There's 3 ways. Yeah, I know. And you're right, though. You're right. So if you didn't know that, what would you do? As a CIS student, and I've been trying to teach you to look things up, what would you do? Do we have WordWeb here? We don't, unfortunately. So what you do is you'd go to dictionary.com, right, and you would look it up, right, or Wiktionary or whatever it is. And since we don't have internet, you're not going to look it up. But if you at home have internet, then what you're going to do is look it up and even see how to pronounce it. Remember, we need to be thorough with things. So if you see a word like this and you're like, oh, these Latin terms. I don't know what these mean. Just look it up. So you're supposed, all CIS students are supposed to have what program installed on their computer? WordWeb. WordWeb should be installed. You control right click, it automatically pulls it up for you, tells you how to pronounce it. You can click on the thing, it'll say how it sounds. Little computer will speak. Yes, and it'll give you the definitions. So don't skip these words, right? Just take a few, it just takes 30 seconds to look at it. So this means the face value. So whoever, the one of the two, the defendant or the plaintiff, whichever one has the stronger face value claim, is to take the oath always. Okay? So whoever has the stronger claim face value will always take the oath. Like if the computer is in my house, it looks like it belongs to me. So on the surface of it, it looks like it's mine. So I'm going to be taking the oath. But if their claims are equal in strength, they are both to take the oath, and then the contract is rescinded, meaning the contract is nullified. If two people are buying and selling or whatever it is, right? They're going to be cancelled. So this is the explanation, and this was Imam Malik's interpretation of the hadith. Those who maintained that it does not have an underlying cause, okay, meaning that this hadith doesn't have an underlying rational reason. The Prophet said this, and we always follow it without trying to understand the underlying reason behind it. Who would this sound like taking a position like that? Zahiris or Ahmad or Shafi'i. So these are the three usual options where they're going to take a position like this. And who usually would say that has an underlying cause? No, that says that it would have an underlying cause. Malik and Abu Hanifa. It's generally the case, right? So we find the same thing happen here. Shafi'i says it has no underlying cause. He said that the husband is to take the oath because the right is claimed by her, and she is claiming an amount in excess to his statement. Therefore, he's the defendant. Right, so she needs to bring the evidence. Right? It is, however, said that they are both to take the oath always, since each one of them is a defendant in one way, but this is held by those who do not take into account the probabilities. I mean, Ibn Rushd is saying, I don't really think that's a very good statement. There is disagreement about this in the school. Which school is he talking about? The Maliki school. All right. Those who maintain that the acceptable statement is hers to the extent of the Mahr al-Mithl, or his when in excess of the Mahr al-Mithl, or of the view that they can never be considered equal contestants in a claim, and one of them has to have a prima facie stronger case. This is so as her claim may either be for a sum equivalent to the Sadaq al-Mithl, Mahr al-Mithl, or less than it, in which case it is her statement that is accepted, or it may be more than that, in which case the acceptable statement is his. So this explains the reasoning for the last opinion. Right? This is not that important, but you can kind of see where it's coming from. This is what they're saying. Right. The reason for the disagreement between Malik and Shafi'i about rescission. So far we've seen the disagreement about who's the defendant and who's the plaintiff. And what is the underlying reason for that disagreement? Whether the hadith should be taken literally, or whether the hadith has an underlying cause, and we look at it from a different perspective. The second issue to look at is the reason for the disagreement about rescission, meaning canceling the marriage contract after taking oaths and reverting back to the Mahr al-Mithl in that case, is whether the nikah is similar to a sale. So why did one of them say you cancel the marriage contract and the other one said no, you don't cancel the marriage continues? Where did they get that from? They didn't just get it from, well, we feel sorry for the couple, so we should just get rid of them. Or you know what, no, this couple needs to stay in the marriage, we should just do it. Scholars don't make judgments on that basis, right? So when they look at it, they have some reasoning in their mind. So this is the reasoning behind it. So they made an analogy that marriage is similar to a type of sale between two parties. What happens when you're selling or buying something? There's a buyer and there's a seller, and they make an agreement, a contract, and then they fight over it. They fight over the price, they fight over the product or whatever it is. So one of them said we should make an analogy like this. The jurist who said that it resembles it, meaning marriage resembles a type of sale between two parties, it ruled for rescission. They said you should be able to cancel the contract just the same way you would cancel a contract in sale if two parties are fighting over what the price was supposed to be. While those who said that it does not resemble it, since the dower, or the dowry, the mahr, is not a condition for the validity of the contract, ruled for sadaqul mithl after oath taking. After you take an oath, we go back to it. So they're saying it can't be like selling, buying and selling, because the mahr is not a condition for the fulfillment of the contract. But in buying and selling, having an agreed upon fixed price is a condition for it. So there's a difference. No microphone. So this is the reason behind it. And the claim of jurists from among the disciples of Malik who thought that it is not permitted to them after oath taking to arrive at an agreement over an amount, or not permitted to one of them to revert to the claim of the other person with consent, is totally weak. So you're saying there's another opinion out there that they're claiming this, whatever. This is a totally weak opinion. All right, so we shouldn't even look into it. Those who held this opinion compared it to the procedure of li'an. So he's saying Yusuf's opinion about li'an, Ibn Rushd thinks that it's not strong. Huh? It was a question, so Yusuf is off the hook. Those who held this opinion compared it to li'an. So what is li'an? Who remembers what li'an is? Cursing, yeah. When the what? When the husband has witnessed adultery or something like that, or the wife has witnessed adultery and they don't have witnesses. So what do? They swear testimony that this, and the last one is going to be a curse. 4 times and the 5th time, right? So there's going to be a curse. So li'an come from la'ana, meaning curse. The last part is the curse. So they're saying that if it's similar to, what if they committed adultery? Do we apply analogy on that certain case of that? They said this is a weak comparison, along with the fact that the similar ruling in li'an is disputed. They're saying this, we shouldn't make this comparison anyways. So he doesn't think that's strong, but some people took that position. In their disagreement about taking, okay, so that's it. That issue's done. We don't have to read from here. Any questions about this issue? Yeah, Yusuf. Still a major sin. If you're swearing by Allah and you're lying, it is still a major sin. There's no doubt about that. So if both of them refuse to take the oath, the marriage remains, because it means that they're both hesitant and they're not sure. So why should they break up a marriage when they're not even sure about what they're fighting over? Right. Yeah. Okay, so that's, yeah, so I think I had mentioned this in this class or maybe another class. So generally, it should be viewed that dowry is a condition of marriage. But in reality, it's not a condition of marriage, in the sense that if don't distract her while she's listening. It's not a condition of marriage in the sense that the marriage contract is completely nullified if you don't have it. So what happens is, if you get married without a mahr, automatically it goes into mahr al-mithl. So you will still get a mahr. So if it was a contract and you forgot to specify the mahr, the nikah that you did is completely invalid. You have to do it again. So that's what they mean by it's not a condition. So it's a requirement, but not a condition. And there's a subtle difference between that. So go back to, it's different. So go to Islamic Law 103, when we talked about the difference between the shart and the, what was it called, like hukum or something like that. There's a difference between a condition and between a requirement. So a condition means the thing is not valid at all. And a requirement is part and parcel of the action, but it doesn't invalidate the entire act. It's considered to be haram, that you're not doing it, and there's going to be some stipulation or something like that. It's very important to see the difference between the two of them. It's like buying and selling. The simple example, buying and selling during Jummah. If the khutbah is going on, and imagine there's only one khutbah, and then someone is in the corner there, and they're selling stuff. He sells something. It's in the middle of the khutbah. It's haram for you to transact business while the khutbah is going on. So let's say someone goes and buys something, and then he comes back out after salah, and he goes, well, actually, this sale was invalid because it was during the khutbah. So you have to return this thing, you have to take this thing back. So is it valid or it's not valid? According to most scholars, the sale is valid but haram. If it's invalid, that means you have to return the product, he has to exchange your money back. These two things never even traded place. So there's a difference between whether it applies or doesn't apply, but it could be haram still. Yeah. Yeah. On the mahar, in terms of if there's a difference, mm, in general, we try to get them to reconcile. You know, in general, though, this never happens before consummation of marriage. So it usually happens after the consummation of marriage. So that's a whole different. That's a whole different scenario. Yeah, and that's what happens. Okay. What is the mahr al-mithl today? Because America is such a diverse community, it's messed up everything. So the range of mahr is between $100 to $100,000. That's the range we have today. Within Southern California. Inshallah. طيب, let's break for salah, inshallah. We'll come right back afterwards. Assalamu alaikum. Okay. Hey, Mom, you might want to stay for this one too. You want to stay for one more? This is a really important one. Okay, I guess not. No, she couldn't hear me. All right, so. Sure. I told her it's the last class. I forgot. This is not the last class, right? It's one more week, right? Yeah. So, well, I got her to come anyways. We should. What happened to this week? We should, inshallah. Who would like to potluck next week? All right. You gonna bring something? Everyone? All right, inshallah. Spicy stuff, huh? All right, inshallah. Alhamdulillah. Okay, inshallah, we'll potluck next week. Just if you could send a reminder on Canvas, and also the day of a reminder on Canvas so people remember not to eat. Inshallah. Inshallah. All right. Bismillah, alhamdulillah, wa salatu wa salamu ala rasulillah, wa ba'd. One of the really big issues is triple divorce. Triple divorce counting as one or counting as three. So the majority, so what does this mean, by the way? If you say talaq, talaq, talaq 3 times, does it count as 3 divorces such that you can never ever be with this woman again? You cannot retract any divorce, and she has to marry somebody else and try and start a new family and all of that before she can, and in case it fails, then she can come back. So this is a big issue. So the majority of the provincial jurists maintained that a triple divorce pronounced once has the effect of the third repudiation. The what? Where is that? In the first part? First part of the page? Which page is it on? Page 72? Yeah, no, we're not going to cover that. No. It's good that you read it though. Alhamdulillah. We should read everything, but we're not going to cover everything. Alright, so we're going to cover this. The majority of provincial jurists, but this is ulama al-amsar, which means the jurists of the provinces, meaning the jurists of the different cities. So most of the scholars lived in major cities. So that's what he means. He's talking about the different cities out there. They maintain that a triple divorce pronounced once has the effect of the third repudiation, which means the majority of scholars said that if you pronounce divorce 3 times, it counts as 3, and it counts as the third divorce. The Zahirites and another group, and I'll tell you who the other group is, later scholars, some early scholars, very few, tabi'een and all that, and later scholars like Sheikh Ibn Taymiyyah and Ibn al-Qayyim al-Jawziyah, they maintain that it takes the ruling of a single pronouncement and the stated number has no effect. So the number doesn't matter. So you can say, I divorce you 160,000 times, and it counts as 1. It's funny because this actually happens. You'd be surprised. This is common in I've seen in Arab cultures. I divorced you 1,000,000 times. Like, okay, there was no need for that. You could have just said 3. They have to take it all the way. I divorced you 1,000,000 times. Right. So yeah, well, that's another issue. So the Zahirites, so we said that. So the Zahirites say it just counts as 1. The proof for these jurists is the apparent meaning of the words of the exalted. Divorce may be pronounced twice. It's a verse in the Quran. So divorce is two times, meaning it can be pronounced twice and it can be retracted again. And if he has divorced her, meaning the 3rd time, then she is not lawful unto him thereafter until she's wedded another husband. Right? Maintaining that one divorced 3 times through words is actually divorced one time, not 3 times. Right? So this is the verse of the Quran talking about 2 and 3. So how many divorces are there? There's 3. They also argued on the basis of what has been recorded by Al-Bukhari and Muslim from Ibn Abbas, who said, divorce in the period of the Messenger of Allah, peace be upon him, and Abu Bakr's time, and in the first 2 years of the Khilafah or the rule of Umar, if pronounced 3 times, was counted as one. But then Umar gave it effect against them. Meaning, after 2 years, when Umar was the Khalifa, he changed the ruling and he said that if you divorce 3 times, it's going to have an effect against you, and all 3 of your divorces are used up. Right? So they also argued on the basis of what is related by Ibn Ishaq from Ikrimah, from Ibn Abbas, who said, Rukana, actually there's another, I read also, it's Abu Rukana, so Rukana or Abu Rukana, divorced his wife 3 times in a single session. Meaning he said divorced 3 times, and then he was greatly saddened in his longing for her. So he said, why did I do that? I want to stay married to her, and this is so common today. You get too many cases like this. The Messenger of Allah ﷺ asked him, how did you divorce her? He said, I divorced her 3 times in a single session, in one gathering. The Prophet ﷺ said, that is a single divorce. Bring her back by revocation. So revoke the divorce, since you pronounce once, you want her back, cancel that, and you can go ahead and have her back. So this hadith states that this divorce counted as one instead, even though it was 3. This is in Musnad of Imam Ahmad. Those who lent support to the majority opinion. So what is the majority opinion? 3 counts as 3. Right? Those who lent support to the majority opinion argued that the hadith of Ibn Abbas, we just mentioned, that has occurred in the Sahihain, in Bukhari and Muslim, it has been narrated from him by one of his disciples, Tawus. Meaning Tawus is the student of Ibn Abbas, and he's the one who narrated the hadith. While the great majority of his students, whose students? Ibn Abbas' students, his disciples, have related from him the binding nature of a divorce pronounced 3 times. Meaning that his other students said that the opinion of Ibn Abbas is that 3 pronouncements of divorce count as 3. So therefore, why is one person narrating that he's saying this, and then the other people are saying that he said that? Among them are Sa'id ibn Jubair, Mujahid, Ata, Amr ibn Dinar, and several others. These are all his students. And that the hadith of Ibn Ishaq is imaginary. It is fabricated. For Rukana, in fact, did not divorce his wife 3 times. This is not even a strong hadith at all. So why would we take that? This is how the professor translated. Professor Niazi, Pakistani, right? So, University of Islamabad or Karachi or whatever, imaginary. Alright, so anyways, so now, if the hadith is weak, that's obviously a problem. Does anyone see an issue in the first argument? Yeah, that one is weak. Yeah. What about the hadith of Ibn Abbas and the fact that his students transmitted a different opinion from him? Is this a good reason for negating the hadith? Why no? Why do you say no? Sana.
It could be different. It could be the hadith could be accurate, but maybe applied a certain circumstance, or they can be reconciled in different ways or interpreted.
Right. Okay. So a hadith could actually apply to a different circumstance, or it could be reconciled in different ways. That's another thing. That's true. So after taking this class, you're like, okay, now there's always a way to do something like this, right? So there's something even more obvious, though. Something more obvious. Anyone catch it? So what is the hadith saying? The hadith is saying that during the time of the Prophet and Abu Bakr and the first 2 years of Umar, the 3 divorces counted as 1, and then afterwards Umar changed it and everyone went with it, and they all started counting it as 3. So this is authentic, Bukhari and Muslim. But then his other students are saying but Ibn Abbas's opinion was that 3 counts as 3. Are these contradictory? So Ibn Abbas in the first hadith is simply saying what happened. He's not saying that he favored the beginning opinion and he didn't change his opinion, or he didn't go with Umar or something like that. So they're not actually contradictory. Ibn Abbas can go ahead and take the other opinion while still reporting the first thing. So it doesn't negate the hadith or the fact that it actually happened. Right? It just means that Ibn Abbas's opinion itself wasn't that. Right? But there's another student, famous student of Ibn Abbas, who narrated that Ibn Abbas did take that position. So like we have seen before, there are 2 contradictory positions attributed to some of these great scholars. And Ibn Abbas is one of them on this issue in particular. And this is what Shaykh Ibn Taymiyyah and Ibn Qayyim, they argue. Okay? So, the reason for so the thing is, if we were to neglect the hadith, then that means if we don't have that hadith as evidence, we don't know what happened during the time of Abu Bakr. Was it actually 3 pronounced as 3 counts as 3, or 3 counts as 1? So the hadith stands, but the opinion of Ibn Abbas is not directly connected to the authenticity of the hadith. That's what I want to differentiate. Do you see the difference between the two? There's 2 things we have to keep in mind. So the opinion of Ibn Abbas, his own opinion, even though he's relating the hadith, that's not connected to the authenticity of the content of the hadith. The fact that during the time of Abu Bakr, 3 used to count as 1. So his personal opinion, whatever opinion Ibn Abbas took, either before or after Umar's time, that's not going to change the fact that this hadith is true. It's authentic. Okay, so we can still take that. So, he has 2 conflicting opinions. His hadith, we don't know what his final opinion is. That's why we have 2 narrations from Ibn Abbas. This is what happens for a lot of companions. You have 2 narrations from them, and we don't know which, we can't favor which one is which. It's hard to figure out which one is which. Right, so that's the issue there. So the reason for the disagreement is whether the ruling of irrevocability that the Shar', meaning that Islamic law, has assigned to the 3rd pronouncement of divorce comes into effect by the subject imposing it upon himself by means of a single pronouncement, or whether this is not the case, and that nothing in it is binding unless it is made so by the law, the Islamic law. That's a tough sentence. So it's basically explaining that, can you, Okay, so I'll explain what it means. So the reason for the disagreement is, okay, the ruling of irrevocability. So if 3 counts as 3, there are no revocable divorces for you. That one divorce that you said with 3 wording in it, you can never revoke it and you're done. You cannot be married to your wife anymore. No chances for you. You lost all your opportunities to remain married. So whether the ruling of irrevocability that Islamic law has assigned to the 3rd pronouncement. So the thing is, in Islam, in the Quran, you're not allowed to revoke the 3rd divorce after you pronounce it for the 3rd time, right? So does that ruling of not being able to revoke something, will it come into effect by the person imposing it upon himself by means of a single pronouncement? Meaning the guy who said talaq 3 times, he basically put on himself the inability to ever be able to retract this marriage again. So he said, I said divorce 3 times because I don't ever want to change my mind, and I don't want to give myself the room to change my mind. That's why people do it, right? They're upset. Said 3 divorces, so that, and I'm never going to change my mind. Even if I change my mind, I shouldn't even allow myself to change my mind. So he's saying that, are we allowed to do this because the person put it on himself, that he's not allowed to change his mind? Or this is not the case, and that nothing in it is binding unless it's made so by Islamic law. So Islamic law says you can only you're allowed to revoke the 1st and the 2nd divorce, but not the 3rd one. So this guy cannot skip to the 3rd one if he never really pronounced the 1st or the 2nd and had any option or opportunity for revoking the divorce. Does that somewhat make sense? It's going to make more sense when I explain the next sentence. No. He did it intentionally. right? But the thing is, what is the underlying wisdom behind revoking the divorce in the first place? That's the issue here. So he says, thus, those who compare divorce to acts for the proper performance of which the observance of conditions imposed by law is stipulated, as in marriage and by the way, this kind of sentence, remember we talked about this in the research class? This is how you never should ever write a sentence like this. Remember that? We talked about all the ofs and the ofs and the ofs. This is what he's doing, right? So performance of which the observance of conditions imposed by law is stipulated, as in marriage and sales. Said that self-imposition is not binding. So if you make an analogy when it comes to marriage and when it comes to sales, that self-imposition of this ruling is not binding. You cannot say that, well, I'll never do this, I'll never do that. So for example, let's say you go to a store and they have a 7-day return policy and you buy something. And you say, I swear, man, I am never going to return this product. I don't care, 7 days, I love this so much, I'm never going to return this product. Now, is that binding upon him, or he still has the potential because there is a 7-day period stipulated? Does your swearing to yourself override the 7-day stipulation that's already there, or does it not override it? So that's the question. So I say, if you compare it to sales, it's not binding. You can't override that because it's already part of the contract. The part of the whole deal is you have a 7-day policy. If you'd say you're never going to return it and then you change your mind on the 4th day, you're still allowed to return it. That's the way sales work. Those who compared it to consecrations and oaths, so when you make some kind of oath in which whatever the subject vows to do becomes binding upon him, whatever its nature. So you promise that if I get an A in CIS, I'm going to fast for 3 days. This is something that you've made binding upon yourself, regardless of what it is. Those people who compared it to this, they made divorce binding in whatever way the subject or the person, the mukallaf, has deemed it to be binding upon himself. So you make it binding, you know. So if you say that if I get an A, I'm going to stand on one leg for 3 hours. Okay, you know, you put that on yourself, right? So it is binding. You swore by Allah you're going to do it. Now either you expiate or you go ahead and you do it, right? And you can have one very strong leg, right? So one leg, right? So has deemed it to be binding upon himself. It was as if, so now he's giving his commentary. It was as if the majority imposed the strict ruling about divorce for, I think blocking is better, for blocking the means. Right? It's Pakistani here. So blocking the means. Do you remember we studied Saddu Dhari'ah, blocking the means to something haram, right? So strict hukam about divorce for blocking the means of exploitation through threat of frequent use. So why did Umar do this in the first place? Look at the history. Why did he change the ruling and say now we have to make 3 count as 3? Because there was exploitation by the husbands that kept on using the threat of frequent divorce. I divorce you, I divorce you, I divorce you, and this and that. Kept on saying. So what happened? It got to such a point where he said, now you should be held accountable for everything you say. So if you say 2, it counts as 2. And if you say 3, it counts as 3, so that you watch your tongue and you be more careful on how you utilize this. Right? So this is, Ibn Rushd is saying this is kind of how it came about. But this view would nullify a lawful exemption whose aim is compassion. So the original ruling was compassion. What is compassion? He says, I mean, in the words of the Exalted, it may be that Allah will afterward bring some new thing to pass. So now, this is assuming that you've already studied all the details and everything. So you go to the verse, 65:1. Let's see if we have internet. Minaret Academy, that's the problem. Minaret Academy. Let's go to admin. Let's see what happens. There we go. Okay, so you go to 65:1 and okay, here. O Prophet, when you Muslims, divorce women, divorce them for the commencement of their waiting period and keep count of the waiting period. And fear Allah your Lord. Do not turn them out of their husbands' houses, nor should they themselves leave during that period unless they are committing a clear immorality. And these are the limits set by Allah. So far it's talking about divorce, right? And whoever transgresses the limits of Allah has certainly wronged himself. You know not, perhaps Allah will bring about after that a different matter. So this is talking about the waiting period during divorce, which is the cooling off period. It says keep count of the waiting period. So we're talking about the period where you can revoke the divorce. And what it's saying is you never know, Allah might bring a different matter afterwards, meaning the husband will change his mind and revoke the divorce and the marriage will continue. So what Ibn Rushd is saying is, where did he go? Oh yeah, I went down. All right. So he's saying, this verse right here, the aim of this verse is compassion. Meaning that, you know what, the compassion that the husband has, and he changes his mind, he calms down, he says, you know what, it's okay, let's revoke this divorce, and we're going to continue marriage. This view, the majority view, would nullify a lawful exception, right, that Allah has given, and that is that you're allowed to revoke a divorce, which is an exception, technically. And the reason for that is compassion, so that the marriage can continue. So you can continue the marriage that way. And he says, if you remove the ability of compassion, that's a problem. You've lost the opportunity to even have something like that. And he leaves it at that. And he's done. Right? So basically, in a nutshell, you have the majority of scholars saying this because they wanted to penalize the husband, because husbands were exaggerating. Now what happened is that people like Sheikh Ibn Taymiyyah, Sheikh Ibn Qayyim and all of them, they came later on and they said, look, that time it may have served its purpose to penalize the husbands for this, but what's happening now is the entire family is suffering. So now someone pronounces 3 divorces, and let's say they have children, or he's not, I don't know if he mentioned children or not, but just looking at it in this context today, they have children, and the man couldn't control himself. Now the thing is, if he can't revoke, now we're going to break up an entire family and not have any opportunity for revoking the marriage. So what many scholars today say is that since we already have family crises, right, looking back at the underlying wisdom of compassion and preserving family and all of that, we should go with the minority opinion. Even though it was a minority opinion, it was still the original opinion during the time of the Prophet and during the time of Abu Bakr and the beginning of Umar's time. So what you'll find in the community is that most of the Arab scholars, when I say Arab, I mean this like loosely. I don't mean this like all Arab countries. It's not like statistical here. Many Arab scholars, though, take the opinion of Sheikh Ibn Taymiyyah. And most other scholars who are strict followers of a particular school, like a Hanafi school or Shafi'i school or something like that, they are, but the thing, what I'm saying is they're the ones who are a little bit more lenient in taking opinions outside of their own school. They're pretty much adopting this minority opinion because of its effect in society, and they believe that it's a better opinion. Otherwise, the rest of the scholars, particularly Indo-Pakistani scholars, even Turkish scholars, and others, they adopt the majority opinion still very strongly. No, but that's another issue. That's a separate issue. That's here, but we're not going to cover it. But so it is still a bid'ah. It is a talaq bid'ah. But does it count or not? Right. Huh? No, I mean Arabs and Desis they both have interesting temperaments. I would I would relate the temperaments both ways. So well, let me tell you what happens in the community first of all. So what happens in the community is we get cases like this all the time, and they say they asked Sheikh so and so, who's from one opinion, and they said we would like to have your opinion. Or they ask Sheikh so-and-so who's from the other opinion, and say we would like to have, the stricter opinion or whatever it is. So This is where people go a lot of fatwa shopping. But they're not fatwa shopping just always for the heck of it. This is their family, it's a pretty big thing, right? So our policy here at IAOC is that 3 divorce counts as one time. That's the general rule that we follow. And if somebody, you know, themselves has already gone to another sheikh and he's given them the ruling that their divorce doesn't count, I mean their 3 counts as 3, we ask them, why are you coming to us then? Like, what's the point? If that person is already giving you a ruling, is giving you a verdict, then just keep going to that person. And I've just wasted a lot of time in back and forth, going, saying no, but Sheikh so and so said this, Sheikh so and so said that. I said, look, our job is to tell you the opinions out there. If you're asking for my opinion or Sheikh Muhammad's opinion, we'll give you our opinion. But we're not going to convince your wife, or we're not going to convince the husband, if the wife comes to us, that you have to follow this opinion or something like that. At the end of the day, the couple has to agree upon something. And in the case where they differ, that's the most difficult, tricky part. So if the wife says no, 3 counts as 3, and the husband says no, 3 counts as 1, I went to the other sheikh. Right? So what do you do in this case? Right? So there's 2 ways of looking at it. One is, if the wife is like left basically and she ran away and she's like 3 counts is 3, we're divorced and this has been 4 months ago and everything, then it's fine. She takes her opinion and she's considered divorced, and you say, okay, just let her go. She wants to be divorced. She believes she's divorced. But if she's still living in your house after like 9 months, right, it means that she, something else going on. So that in that case, I say the husband's statement or the husband's opinion of which scholar to go with, which opinion to go with, that takes precedence. So this is so sometimes each case generally though, I think I'm more inclined towards this minority opinion. No, but so these are all different. So these are all different cases which we're not covering. So divorce pronounced in anger, does it count or not? Divorce pronounced without the intention. So was the man thinking or he wasn't thinking? Was he in a straight man or did he mean 3 or did he accidentally say 3? Did he write 3? So these are separate issues. Ibn Rushd has a whole discussion on all of these. We'll never finish anything if we keep on going into details on that.
So when you're saying the majority opinion, it's not it's not meant to be someone saying it in anger or someone saying intentionally. How are we supposed to interpret this?
Hmm?
So how do we interpret that the guy is saying it?
How do we interpret? So the guy is, he's obviously upset. It's just general. So he's upset, right? But he's calm enough to know what he's saying. He's doing it with the intention. Yeah, he's like, I'm done with this, and I've had enough. And you're divorced 3 times. I don't even want to ever revoke this divorce anymore. Consciously saying that's the only reason why someone would generally say. Most of the time, a man would do that because he's getting so upset in the sense that I've made up my mind 100%. I mean, most people do divorce out of anger in one sense, but it's built up anger versus state of the moment anger, right? So if he's doing it over built up anger and resentment over a long period of time, he understands what he's saying. He knows what he's saying, and he's saying, and that's it. I don't want to be married to you at all, and I don't want to ever change my mind. Now, if he doesn't change his mind in 3 months or whatever, okay, great, no problem. But when he changes his mind in 1 week, which is normally the case, so many times it happens, what have you done? You've actually removed the ability for the guy to change his mind. So that's the issue. Yeah, but jest is another completely different issue. Whether he's joking or not is a different issue. So whether someone is joking, whether someone is angry, whether someone intended it, and whether 3 counts as 1, there are 4 different issues. It's separate, and when you're dealing with a divorce case, you have to consider all 4, but we're only studying one of them for now. Inshallah. That's a good question. I always wanted to research this. I don't know if this was the opinion that he was thrown in jail for or not, but if you have the research, I would love to see it. Did you see it? You read it? Do you have the source? Yeah, get us the source, inshallah. I would like. It was Sheikh Ibn Taymiyyah thrown in prison for having this opinion. So he was thrown in prison for something. I don't recall what it was, whether it was this or something else. But if it was, let us know next week. This is your homework assignment, inshallah. Research paper, inshallah. Due next week. What if he what? Yeah. He does another 3 times. Then it counts as another one. It counts as one again. Yeah. Yeah, but he can only do this 3 times. Right? So he does three and it counts as one. Okay? And then he does three again, it also counts as one, but it stays, the tally stays. And then he does three again, even if it counts as one, that's his third divorce. So he's done. It's true, but at the same time, I mean, let's say he does this, okay? How many times can you throw it around, right? You only get 3 chances. So it's still, like for me, it still ends up being, you should get 2 chances, right? So even if you throw out 3 or you throw out 1,000,000, that still counts as 1 chance. You throw out more than 3 again, that counts as a second chance. Now you're done. Whatever you say, even if you throw out half a divorce, you're gone. I don't actually know if half divorce counts or not, but assuming you throw out 1 or more, whatever it is, you're done. That's it. And it's final. We're talking about life final for the most part, because most people are not going to remarry and then actually break the relationship out. Remember, muhallil marriage is not allowed. So we're not talking about that. The muhallil means that you just played a trick and you married some random guy and then you slept with him and then you divorced him, so that with the intention of marrying your first husband. This is completely forbidden, right? And I don't know why it became a trend somehow in the Indian subcontinent. I've heard this is ridiculous, but that's not allowed in Islam. It means that you move on, and if that other marriage fails, then you can go back to the first one. Otherwise, you can never go back to the first one. Because they saw abuse in their time, and they wanted to do saddu zari'ah, which means blocking the means to something which is haram. When we come to interest, maybe today, you're going to understand why they did it, and you're going to appreciate even why they did it a little bit more, because it makes sense. If you only stick to the literal ruling, you're going to say, oh man, if we allow things like this, we're going to get into a major problem. So we're going to talk about Islamic finance and the whole Islamic finance industry, maybe today or next time, inshallah. All right, so let's move on. Are we done? Any other questions? One question. Is what applicable? The divorce? So women can't divorce. She does khula. So khula is different. The rulings are different. So we're about to cover khula right now. It's like coming right now. So in here. Is this the one? Person repudiating? No, it's coming. Okay, so does anyone have the syllabus? Are we doing we're doing 19.1.2.2 or no? Only 3, right? Okay, 3 and 4. Okay. The jurists disagreed on a number of points about the case of the person who repudiates during the menstrual period. Repudiates meaning divorces. Okay. Again, this is Pakistani terminology. Okay. So the jurists, they disagreed. Are you allowed to divorce during the menstrual period, and what happens if you do? The majority held that his divorce takes effect, while another group said that it is not to be implemented or considered. Those who maintained that it is implemented said that he is to be asked to take her back, but then they became divided into 2 groups. So, first of all, according to the majority, it's not allowed for you to divorce a woman while she's in her menstrual period. But those who took this opinion, which is like almost everyone, they said, what if you do divorce her in the menstrual period? Does the divorce count? And they said, well, if the divorce does count, then you're asked to take her back. I mean, you have to revoke the divorce. How do you revoke the divorce? One of the groups held the view that it's obligatory and he should be forced to do so. So the man is forced by somebody, like a judge or Islamic scholar or whatever, to take the divorce back and continue the marriage. This was the opinion of Imam Malik and his students. The other group, they said that it's recommended for him to do so, but he is not to be forced. This was upheld by Ash-Shafi'i, Abu Hanifa, Al-Thawri, and Ahmad. So Imam Malik says you force the man, and the other scholars said no, you don't force him, but it's recommended that he takes it back. But it's still haram for him to do so. So it's forbidden, but the question is, do you force him to revoke the divorce or not? Those who made retraction obligatory, like Malik, they differed about the time period in which such compulsion is to take place. Malik and most of his disciples, Ibn al-Qasim and others, they said that he is to be forced as long as her period of waiting is not over. So as long as the divorce period of waiting, which is how long? 3 menstrual periods. If as long as that does not finish, then he's forced to take her back. Ashhab, from students of Malik, maintain that he is to be forced only up to the time of the first menstruation, meaning the time in which he did it, he's only allowed to be forced at that time. Afterwards, you don't force him to retract. Those who held that he is to be ordered to take her back differed about the time when he may do so, if he wishes to divorce her after he has taken her back. This is an interesting issue. So if you divorced your wife during her menstrual period, and then you're forced to take her back, are you allowed to divorce her as soon as her menstrual period is over? So this is the interesting. One group stipulated as a condition for the restoration of her status that he has to retain her until she enters the period of purity after the menstruation, menstruates there another time, and then enters another period of purity. So meaning that if you divorced your wife during a menstrual period, you didn't do it correctly, you're forced to revoke the divorce. It counts one against you, and you have to wait until an entire period of purity and another menstruation and another period of purity before you can even divorce your wife. That's the penalty of you actually divorcing her in the wrong way. It is then that he may divorce her if he likes, or he can retain her, he can keep her afterwards. This was the opinion of Malik, Ash-Shafi'i, and another group of jurists. So many people took this opinion. Another group said that he can take her back, he takes her back, and when she becomes pure after the first period of menstruation in which he divorced her, he may hold on to her if he likes, or he can divorce her. This was Abu Hanifa's opinion and that of the Kufis. Yeah. So the Kufis are scholars who wear kufis. Yeah, scholars from Kufa, city of Kufa. Right. So Imam Abu Hanifa and those Kufans, what did they say? They said, even if he messed up and he divorced her during her menstrual period, as soon as menstrual period is over, he's still allowed to divorce her. Whereas the other ones, they said no, they're not allowed to do so. All those who stipulated for talaq sunnah, meaning the right way of divorcing, that he divorce her in a period of purity during which he has not cohabited with her, did not require him to take her back if he had divorced her in a period of purity in which he had cohabited with her. So if you remember from 102, when are you supposed to divorce your wife? According to Sunnah. If you're going to okay. What? When she's not in a state of menstruation, that's one. And number two, and they've not had intercourse during that purity period. So 2 conditions. So he's just throwing this in. He's saying, and those people, if he divorced her after having intercourse in that cycle, there is no requirement for him to take her back. So you don't apply analogy to the divorcing during menstruation time. Even though they're both recommended things to do, they both should not be done. One of them has more severity and the other one has less severity.
So menstruation and the one to wait for the entire period they're both not requirements, they're just recommendations.
One of them is forbidden, which is the menstruation. The other one is also, I don't know if it's forbidden or really extremely disliked, right? but one of them forces you to take her back, and the other one does not force you to take her back. That's right. And then in summary, there's 4 issues. Right? First, is the divorce even valid or not? Second, if it is valid, is he to be forced to take her back or only required to do so? Third, when does the divorce come into effect? After such compulsion or after recommendation? So when are you allowed to actually do a final divorce? And fourth, when is he to be forced to do so? The reason for the differences? Which one? For the forcing? So it basically comes back to, is this, yeah, there's hadith of Ibn Umar, that's one of them. So Ibn Umar divorced his wife, and the Prophet ﷺ said you have to take her back. So you have to revoke the divorce. He divorced his wife during the menstrual period. So that's one of the main reasons where it comes from. And also, reasoning of whether something which is haram takes effect or doesn't take effect, and whether you need to nullify it immediately. Kind of what we were just talking about, like the buying and selling during Jummah. So even though it's haram, does it have to be revoked? Do you have to cancel the contract, or do you maintain the contract or whatever? So does it, if the divorce counted, do you have to cancel the divorce or not? Right? That's kind of the issue. Okay, so now you're talking about a different issue. So you're talking about the issue of the force one. Yes. So they differed on this hadith as well, in terms of, was this a recommendation for Ibn Umar or was it something mandated? He has to do this. It's different how you interpret the incident. Same hadith. Yeah. So he understood it differently. That you're not forced to take her back, but it's recommended. So it's like the two units of prayer when you enter the masjid. And we talked about that, right? So is it mandatory? Because it sounds mandatory in the hadith, but majority of scholars said it's recommended. Even though it looks like it's mandatory, it's not. Right? So it's the same thing. How do you interpret it? Well, Jummah is another thing, but generally the ruling for Jummah applies to the same as the other rules, even though there's a hadith of that one man and all of that, All right. Divorce. Any questions on this issue? These are women's issues. Actually, they're men's issues too. So. Okay, what's the next one? It's this one right here? 1.2.4? Okay. The majority held that if the divorce occurs during the period of menstruation, the hadith is coming. It is to be deemed a legitimate divorce because of the words of the Prophet, peace be upon him, in the hadith of Ibn Umar, order him to take her back. So he told his companions, when he heard about what happened, tell Ibn Umar to take her back. He has to revoke the divorce. They maintain that raj'ah, or returning, does not take place except after the divorce. So they said, how can he take her back if the divorce didn't actually count? So they're arguing that the divorce must have counted. That has to be the case. It is related from a Shafi'i, from Muslim, Ibn Khalid, from Ibn Jurayj, that they sent someone to inquire from Nafi' whether he had taken the report about the repudiation of Ibn Umar, which took place during the period of the Prophet, into account. He replied in the affirmative. It is also reported that Ibn Umar used to issue verdicts in accordance with it. Are you sure we're covering this point too? It's in the syllabus? It's not, right? That's what I thought. Okay. So. It is? 19.1.2.4? It is? Okay, it is. Okay, let's continue. Those who did not consider such a divorce to have taken a legal effect relied upon the general implication of the words of the Prophet, every act and deed not based upon our practice is rejected. This is took it general. If it's not there in the Sunnah, then we don't follow. You have to have a specific to override it, and that has to be a strong instance as well. They said that its rejection by the Messenger of Allah implies its non-implementation and invalidity. So they took general principles. The reason, however, for the disagreement here is whether the conditions stipulated by the shar', which means Islamic law, for the talaq as-sunnah, the correct way of divorcing, are conditions of validity and implementation, or those of completion and perfection. So again, are we talking about validity, or are we talking about what's the right word? Perfection, meaning completeness, right? Yeah, that's completion, meaning that the act actually is done in the right way. So again, it's conditions versus requirements. What is condition? What is requirement? Those who maintained that they are conditions of implementation said that the divorce does not take legal effect when it does not conform with this description. Those who held that they are conditions of completion and perfection said that it does take effect, but it is recommended that it take its full, perfect form. Therefore, those who upheld the occurrence of divorce and then compelled him to retract have contradicted themselves. Ponder over this. So he's taking a stance here, right? So this doesn't make sense. Okay, and that's done there. Any questions on that one? No? Okay. Regarding the conditions in which redemption is permissible. Okay. So again, Pakistani translation here. Redemption is referring to khula, meaning when the woman petitions for annulment of the contract. It's like the divorce from the woman's side. All right, so he's calling this redemption. So what are the conditions in which a woman can get out of the marriage? When is she allowed to do that? When is it permissible? He doesn't really cover much of this at all, so I just put in whatever he covered, the minimal of what he covered. The majority held that it is permitted with the mutual consent of the parties. As long as they both agree, the husband agrees as well, then she can get out of the marriage. Unless consent to pay him is obtained by fear of injury to her. So now there's a problem. What if he's not granting it because there's some type of injury that could afflict her? Injury, we're talking about monetary injury, meaning that she's going to end up losing more money trying to get out of this marriage, because part of the getting yourself out of marriage is you're giving up part of your dowry. So if he's putting pressure on her to get back the dowry that he gave her, and she's not really done anything wrong, she deserves to get out of this marriage, then if there's injury to her, meaning financial injury, then in that case, we're going to look at a different circumstance. Is the basis for this, that we wouldn't injure the woman financially, are the words of the Exalted: O you who believe, it is not lawful for you forcibly to inherit the women of your deceased kinsmen, nor that you should constrain them that you may take away a part of that which you have given them, unless they be guilty of flagrant lewdness. So this verse, the second part of the verse, is talking about here. It is not lawful for you to constrain them, right, to make life very difficult for them, so that you will take away part of what you've given them, meaning part of the mahr that you've given them. So imagine there's a guy, he gave a lot of mahr to his wife, let's say 10,000 or whatever, and he wants that money back. And if he divorces her and he wants to get rid of her, what's going to happen? She gets to keep her mahr because he divorced her. So what he could do, if he's slick, if he's smart and clever, he could make her life miserable and just treat her really, really bad. So she's like, I just want to get the heck out of this marriage. I don't want to deal with this. Take your mahr back. I don't care anymore. So Allah subhanahu wa ta'ala says in the Quran, knowing that guys could be slick like this, saying that this is not allowed. You're not allowed to do this, right? So it is haram for you to do something like that. So that's one verse which talks about this issue. And the other one is, and if you fear that they may not be able to keep the limits of Allah, meaning the husband and wife, in that case, it is no sin for either of them if the woman ransom herself. Meaning go ahead and give some of the mahr back, and she can get out of the marriage. These are the limits imposed by Allah. Okay. Abu Qalaba and Hassan al-Basri. So there's a bunch of weird opinions coming out here. Abu Qalaba, Hassan al-Basri, they deviated from this opinion, right? The word deviated is good here. With both maintaining that it is not permitted to a man to contract redemption with his wife unless he's seen her committing fornication. So maybe somewhere in some part of the world you heard that there's an opinion where a woman cannot get out of the marriage through khula unless he's committing fornication. This is a deviant view, meaning it's like a very, very minority view. Almost nobody goes with this view. They interpreted the term lewdness. So the word fahisha in the verse which says, where is lewdness? If you fear that they may not be able to keep the limits of Allah. Oh, here. Unless they be guilty of flagrant lewdness. So they interpreted this word lewdness, fahisha, in the verse as fornication. Dawood, the Zahiri, he said it's not permitted except in the case of fear that they will not be able to maintain the limits imposed by Allah according to the apparent meaning of the verse. And Nu'man also deviated to saying that redemption is permitted even with the threatened injury. Yet, so he's saying all of this is some deviant opinions. These are not, opinions that we should even take into consideration at all. Yet, the juristic reasoning is that fida, so he's saying the real opinion that people should follow, the word fida or ransom in the verse grants to a woman something equivalent to what is possessed by the man, namely the right to divorce. So the word fida here, ransom, actually has the same implication of that she gets the same thing that the man gets in the way that she can divorce in a way, but it's just not called divorce. A man possesses repudiation when he pressurizes a woman. I didn't even go back to the Arabic, but this is just weird English, right? While a woman possesses khula when she wants to pressurize a man, i.e. her husband. So meaning when a man wants to divorce his wife, he uses talaq. When a woman wants to divorce her husband, she uses khula. That's what it means. So we have 5 opinions. 5 opinions are thus derived for khula. First, it's not permitted at all. It's a deviant opinion. Second, it is permitted under all circumstances, even under duress. So even if you're forced to do so, it still counts. Third, it is not permitted unless fornication is witnessed. So this second one is also minority opinion. The third one is also a minority opinion. Fourth, it is to be permitted when there is fear that the limits imposed by Allah will not be maintained. That's Dawood again, minority. Fifth, it's permitted in all circumstances except under duress. So it cannot be done by force, which is the most widely accepted mashhur opinion among the scholars. So that's the real opinion that we should follow. If a woman ever wants to get out of marriage, she can. She does it by way of khula for whatever reason, right? She doesn't, if she has a good reason, then she should not have to give up much of her mahar at all. And if she doesn't have a very good reason, like, the guy he doesn't work out enough. He should go to the gym more often, but he doesn't, he's lazy. Therefore, if it's not that good of a reason, then she should at least give something back in exchange, especially if he gave her a lot. Or he squeezes the toothpaste. Yeah, exactly. Alhamdulillah, yeah. 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 In cases of abuse and all that, she should not give anything back. No, she should not give anything back. All right. Are we covering this one? 1.2. I don't think so. Relating to waiting periods, agreed that a woman undergoing. No. So this was in the syllabus, and I'm canceling it. So we're skipping this one. You can cross it out. Of the what? Yeah. Yeah, they're all based on the verse. They're all based on the verse. But there's other hadith which clarify, One woman, she asked, to get rid of her husband. She just didn't like the way he looked. She said, I can't stand looking at him anymore. The Prophet ﷺ said, okay, well, he gave you a whole garden. Like, it's very expensive, like a garden, you know. So as mahr, she said, are you willing to give the garden back? She's like, yeah, man, I can't stand looking at the guy. He can have his garden back. She gave the garden back, and they got separated. So there's a lot of other hadith on that. Yeah, yeah. She said, yeah, he fulfills his responsibility. He's a good husband and everything. I just don't like looking at him. So, alhamdulillah, what are you going to do? So, that's me. So, khair. Waiting period following the husband's death? No. Yeah, so we're skipping that one. We're going to cancel that one. Sales through usurious means. Here we go. Okay. So this one's really interesting. So here is a situation which the parties confront when one of them stipulates excess or loss through a negotiated rescission, meaning negotiated canceling of the contract. So the parties may enter unintentionally into an injurious sale. So what does injurious sale mean? Here it means basically two people are transacting something. They can accidentally get into some type of contract which is haram and harmful without maybe even realizing it. And how does it happen? If one of them purchases from his companion something that he is selling with an excess or with the loss. So for example, a person sells to another person goods for 10 dinars in cash, and then he purchases the same goods from him for 20 dinars on credit. Okay, so think about this example, right? So I sell Kenny my watch. I say, you know what? I'm going to sell you this for 10 bucks. Okay? So he buys my watch and he gives me $10. And I have $10, he's got a watch. Okay? And then afterwards, for some reason, I say, man, Kenny, that's a really nice watch. I need to buy that watch back. I'll give you 20 bucks for it. She's like, oh, 20 bucks? It was your watch, but I want it back. She says, okay, I'll go ahead and sell it to you for 20 bucks. But I say, you know what, I don't have the money right now. Can I pay you after 1 month? And he says, yeah, no problem. 20 bucks, pay me after 1 month. So what happens? He gives me the watch back. I have his $10 in my hand, and I owe Kenny $20 in 1 month. So actually what just happened? This was already my watch. Technically, now I have the $10 that Kenny had in my hand, and I owe Kenny $20. So what's the difference between this and Kenny just giving me a loan of $10 and I got to pay him back 20 bucks after a month? It's like interest. All right, so you see the problem now, right? So this could be maybe unintentional. What ended up happening, there was an item that was switched along the way, looked like a valid contract, like a two sales combined together, but in the end, it ends up, when you look at the end result, Kenny gave me 10 bucks, I owe him 20 bucks in a month. That's interest. That's the problem. So what happens when something like this happens, you got an issue. So so when the second sale is related to the first, it becomes apparent that one of them has paid 10 dinars in exchange for 20 with a delay that you're allowed to pay later on. Such transactions are called deferred sales, buyu' al-ajal. We shall mention out of these only the issue of the negotiated rescission. Skip that sentence. Okay, why? This is nice, the last part of the sentence. As related to the issue of delayed sales, for the purpose of this book is the extraction of principles, not detailed opinions. So you notice we're not interested in covering detailed opinions. We're only looking at principles. Even though we learn a lot of opinions, this is not the goal of this book. It's about usury, yeah. But he's reminding us of the purpose of his book again. It's not to teach you all the rulings. You take another class for that, right? But here, you just want to learn the principles of how to reason things out. That's the goal here. So we're going to skip down to, let's see. Reason is that iqala and then regrets demands. No, we're skipping this one. Right here, 9 issues, 2 of which are disputed. So this is related to what we just covered right now. The person who sells a thing with a delay and then purchases it again, he will purchase it with delay of a period ending at the same time as the sale, or prior to it, or later. He's just being Aristotelian here. Looking at all, he's, like I said, he's being just logical. He's saying these are three logical possibilities that could exist in reality, right? And then don't worry about that sentence. In each of these three cases, he will purchase the thing for the same price for which he sold it, or for a lesser price, or for a higher price. This is the problem with philosophers, right? They state the obvious. Obviously, you're going to pay the same price, or you're going to pay the lower price, or you're going to pay the higher price. Everyone knew that. You didn't even need to say that. That's obvious, but they define things like that. 2 out of these 9 cases are disputed. So that's why he mentioned it. Permutation. Huh? 172, page 172. So 2 out of these 9 cases are disputed, and these are when he purchases during the period for cash at a price that is less than the price that's taken, or that he purchased it for a higher price with a period of delay lengthier than that of the actual sale. The example is going to make you understand all of this. According to Malik and the majority of people at Medina, this is not allowed. Ash-Shafi'i, Dawood, and Abu Thawr said it is permitted. So keep in mind, again, you see the same thing. Ash-Shafi'i is known for a little bit more literalism. Dawood is known for all the way literalism. And Abu Thawr is also known to be in the same camp as these guys. The reasoning of those who disallowed it is based upon the consideration of the relation between the two sales. So the ones who said it's not allowed, which is, who said it's not allowed? Malik. So he's saying you have to look at the two sales together. You don't look at them separately, you look at them together. They suspected that the intention is to pay a greater amount of money for the sake of a delay, and this is prohibited riba. This is interest and it's haram. So for example, if somebody sees me selling my watch to Kenny and then buying my watch back for a greater price, but I'm waiting for a delay, someone looking at that from the distance say, wait a minute, man, that looks like interest. No, it just so happened that I sold it to him and then I changed my mind, I needed more. You would look at that and say, why would anyone do this, right? So the question is, do you judge the person's intention, or do you look at the outward aspect and say, this looks exactly like riba, it needs to be prohibited, it should not be allowed in the books or anything. So they suspected that the intention must be to get some type of riba benefit. A false form of the transaction was therefore concocted so that the parties could obtain haram, and it is the same as a person. So it's saying they just made up this little transaction just so that they could achieve something which is haram. And it's just like one person saying to another person, look, man, lend me 10 dinars for 1 month, I'm going to repay you 20. So I do the same thing. Kenny, man, give me $10, I'll pay you 20 later on. And he responds, it's not allowed, that's haram in Islam. But instead, how about I sell you this donkey for 20 dinars on credit for 1 month, and then I buy it back from you for 10 dinars on cash, or vice versa, the other example. So you could do the same little switcheroo and achieve the exact same result of getting the loan that you wanted. So in the rest of the cases of the problem, there is no suspicion of an underlying intention. So all the other ones, these are the 2 cases where you can modify, make 2 contracts related to one another and make it seem like they're 2 separate things, but in reality you're getting the exact same results as if it was interest. Now, this is problematic because Imam Shafi'i, Imam Abu Thawr, Imam Dawood, they say this is allowed because you don't judge the person's intention, so therefore you do not ban the contract, right? So now, coming back to Islamic finance, this becomes a problem because in Islamic finance, you have a ton of different contracts being combined together into one contract. So how do you look at it and say the end result is very similar to riba? This is the most common argument that the average, not even educated person about Islamic law, what do they say? Islamic finance and the normal finance, they're like the same. I don't see much of a difference between the two. So on what basis are they saying that? They're saying it on the same basis that it looks like the end result is similar. So is there a real basis for this or not? So this is where things become tricky and become difficult. And then the argument is, look, if you have, and I don't know if I've heard of this or I made this up myself one day, but if you have a salad, the lettuce is halal, the tomatoes are halal, the croutons are halal, and the carrots are halal. Everything is halal. You put all of them together, can you get haram out of that? No. But according to Imam Malik, it's halal for me to sell my watch to Kenny, and it's halal separately for Kenny to sell the watch back to me. It's halal and halal. When you put them together, it's haram. So you could put halal things together and it ends up being haram because you look at the net result of what that was supposed to achieve in the first place. So this is what's happening. Imam Shafi'i and the others are saying, no, we don't judge, we keep them separate. And Imam Malik saying, no, just think about it. Look at the whole thing together, and it doesn't matter what the person's intention is. In society, if we imagine in society, everyone is allowed to go ahead and make these contracts. And the government is looking at the contract and says, oh, well, Kenny sold his watch, Mustafa bought it back and everything. But we can't ask them what their intention was, right? So it's okay. So everyone who wants to deal in riba will deal in riba in that society. So Imam Malik is looking at this from a perspective of what should the government do? Should they stop this and ban this and tell people this is not allowed, you're not allowed to do this? Or do we tell people, look, if your intention is riba, then you're going to be held accountable. But if your intention is not riba, then it's okay to go ahead and do that. So again, remember I told you there's two schools of thought that have been implemented in practicality throughout Islamic history. What are those two schools of thought? Shafi'i? On a large scale. Okay, who implemented the Hanafi school of thought? Ottoman Empire. Who implemented the Shafi'i school of thought? There was no, Imam Shafi'i wasn't alive. Huh? Malikis. Where was it implemented? North Africa and Spain. So the only two madhabs which were implemented across the board were Hanafi and the Maliki school. And some of the, like my teacher used to say, and there's a reason for that. He was Maliki himself, but he said there's a reason for that. It's because they look at things from a state perspective and not just from a individualistic perspective. They look at things from a communal perspective, and that's why they're more applicable to being implemented in a community in particular. So that's that. So this is a very interesting thing. Reflect upon this and then reflect upon Islamic finance. So let me tell you, in Saudi Arabia, there's a contract known as tawarruq, and Islamic banks, they use exactly this contract. So what they have is, you walk into an Islamic bank and they have a master safe with a bunch of commodities inside the safe. So you walk in, you say, look, I want to buy a house. And you say, well, you'd like to buy a house, but you can't afford it. We are not allowed to give you an interest-based loan. So what we're going to do is, we're going to sell you some of the commodities inside our safe. So you sign the contract, and in the first part of the contract, you buy some of the stuff that's in the safe. And then what you're going to do is you're going to sell those things back to us, right? And you sell it back to us with profit and loss and all that stuff. And in that case, we're going to go ahead and pay you since we actually bought something from you. But the things never left the safe. They stayed in the safe the whole time. So Imam Malik would be just cringing, thinking, what are you guys doing? This is exactly what he's talking about. And as soon as one of the princes of Saudi Arabia, he was asked, can we make this economy Islamic in Saudi Arabia? He was against it the whole time. Then when they explained to him this model, and they said, look, we can do this tawarruq model with the safe and everything, he was immediately, let's Islamize the entire country. Why is he all of a sudden become interested? Because on the outward of it, this is like a sham, right? Nothing leaves the safe. Everything sits in the safe. You're pretending like you're buying something and then you're selling it back. Nothing is changing. You're not taking any of this home. This is a commodity. And they say, well, you could have taken it home if you wanted to. Okay, imagine there's whatever. Imagine there's some, I don't know, something that doesn't expire quickly, right? Let's say there's oil. Okay, let's say you're selling oil and selling it back. who's gonna take the oil barrels home, right? Nobody's gonna do it, right? So you know what's going on, right? This is the same thing that's going on. So these contracts can become very problematic. Now, if you look at legal language, lawyers who work for the banks, they're trying to change the wording all over the contracts to give some advantage to the bank. That's their job, right? So they're trying to add little things here, little stipulations there, which keep on modifying the contract. And that's why it's like a battle between scholars to understand the contract and understand what the lawyers have added, understand how this condition affects that part of the contract, this condition affects that part of the contract. It becomes very, very sticky. So this is a very, very relevant issue. And it makes a difference in terms of how you deal with all of this. Any questions on this before we break for Isha? Yeah.
Do the scholars take into account the time period that the selling and the rebuying takes place? Because say something that is, if this is something that actually does change your value, like perhaps you buy it 1 year and you sell it for what, 200,000, and then you buy a few years later for like 500,000. So then it's like a legitimate like price increase according to market value. So do they take that into account, or is it kind of like
They do take it into account, but you never know exactly what's going to happen. It depends. Like housing market is going to fluctuate. It could go the other way. So there's no guarantee. Something that what?
something that would still be prohibited?
It would. I mean, an increase on it. So we're talking about increase and we're talking about fluctuation. So fluctuation, you never know which way something is going to go. So that's the thing. So the only thing which could potentially be an argument is the inflation rate. That's something that's also not fixed. But bankers, economists assume that it's been fixed over a period of time. That's another thing we can discuss that, inshallah. I know. Let's talk about it after the break, inshallah. Assalamu alaikum.
الله أكبر الله أكبر أشهد أن لا إله إلا الله أشهد أن محمدا رسول الله هيا للصلاة هيا للفلاح قد قامت الصلاة قد قامت الصلاة الله أكبر لا إله إلا الله استووا مستقيم الله أكبر الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين ليس البر أن تولوا وجوهكم قبل المشرق والمغرب ولكن البر من آمن بالله واليوم الآخر والملائكة والكتاب والنبيين وآتى المال على حبه ذوي القربى واليتامى والمساكين وابن السبيل وفي الرقاب
والأنثى بالأنثى فمن عفي له من أخيه شيء فاتباع بالمعروف وأداء إليه بإحسان ذلك تخفيف من ربكم ورحمة فمن اعتدى بعد ذلك فله عذاب أليم ولكم في القصاص حياة يا أولي الألباب لعلكم تتقون كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين فمن بدله بعدما سمعه فإنما إثمه ولكم في القصاص حياة يا أولي الألباب لعلكم تتقون كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين الله أكبر سمع الله لمن حمده الله أكبر الله أكبر الله أكبر الله أكبر الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين فمن بدله بعدما سمعه فإنما إثمه على الذين يبدلونه إن الله سميع عليم فمن خاف من موص جنفا أو إثما فأصلح بينهم فلا إثم عليه إن الله غفور رحيم يا أيها الذين آمنوا كتب عليكم الصيام كما كتب على الذين من قبلكم لعلكم تتقون أياما معدودات فمن كان منكم مريضا أو على سفر فعدة من أيام أخر وعلى الذين يطيقونه فدية طعام مسكين فمن تطوع خيرا فهو خير له وأن تصوموا خير لكم إن كنتم تعلمون شهر رمضان الذي أنزل فيه القرآن هدى للناس وبينات من الهدى والفرقان فمن شهد منكم الشهر فليصم ومن كان مريضا أو على سفر ولتكملوا العدة ولتكبروا الله على ما هداكم ولعلكم تشكرون وإذا سألك عبادي عني فإني قريب أجيب دعوة الداع إذا دعان فليستجيبوا لي وليؤمنوا بي لعلهم يرشدون الله أكبر سمع الله لمن حمده الله أكبر الله أكبر الله أكبر الله أكبر الله أكبر الله أكبر سمع الله لمن حمده الله أكبر الله أكبر الله أكبر الله أكبر الله أكبر
It's a rare asset to to learn this thinking part. Um, yeah. Yes. Yes. Yeah. All right. Bismillah, alhamdulillah, wa salatu wassalamu ala rasulillah. So this is one of those things where it looks like there's a hole inside the sharia or the law where people can kind of get around it. So we should be aware of these things. So keep in mind the opinion of Imam Shafi'i. This doesn't mean that there's a real difference of opinion on this issue. Imam Shafi'i and the others, they're actually saying that if your intention is riba, it's still haram. It doesn't mean that it's halal. It just means that we're not going to regulate in society. We're not going to look into your intention. But if your intention really was to get a loan, Allah's going to hold you accountable for that. Likewise, think about zakah. If you transfer all your money into your wife's account after 6 months, and then she transfers all that money back into your account after 6 months, and you keep doing that, you never have to, no one has to pay zakah. But let's say you're doing that for some other reason outside of zakah evasion. It's like tax evasion, zakah evasion. Then that may be a different case. But do we look at it from a government perspective where if we see people doing this, we need to put a stop to it because it can be a way for people to get out of zakah? That's what Imam Malik's saying. Regardless, anyone who looks at inside and says, if this is your intention, it's haram. No one's going to approve you of doing that. And there are people who do this. I think I talk about zakah laundering. I talked about it, right? So people are doing zakah laundering. They're doing zakah evasion. They're doing all sorts of things. Zakah shelter. Exactly. So we have zakah seminar coming up, inshallah. Very soon. I have to figure out a date for it. We should invite everyone, inshallah. Yeah. I wanted to. So inshallah, someday we will teach an Islamic finance course. Ah, and they're salted. So on a small scale. Yeah, well, the Hanbalis were adopted by the Saudis as well, so technically. But I mean on a large empire scale. But yeah. All right, where are we? Any other questions on this one? We're clear? Let's continue then. Sale proscribed on account of misappropriation, the cause of which is gharar. Alright, so this is long. I didn't actually go through and filter this out. Let's just start reading and see how far we can get, inshallah. Yeah, so gharar means uncertainty. Yeah, it's uncertainty in a transaction, and the vast majority of economic transactions today which are problematic are either due to one of two reasons, either due to usury or due to gharar. And I would say more of them are forbidden in Islam because of gharar than there are because of interest. So this is something where most people don't understand. They don't understand what gharar is and how it affects a contract, and therefore they don't see the problem in many of these transactions. So these are sales that are proscribed, meaning they're forbidden on account of misappropriation, the cause of which is uncertainty. Gharar is found in sales from the aspect of jahl, meaning having a lack of knowledge of what you're buying, in various forms. Number one, from the aspect of ignorance. Jahl means ignorance. So from the aspect of ignorance caused by the failure to identify the subject matter of the contract or failure to determine the contract. So if you're not sure exactly what the contract is supposed to actually mean, it results in gharar, and therefore it's forbidden. Number two, from the aspect of ignorance about the attributes of the price or the priced commodity, or about the quantity or the deferred period of delivery if there is one. So number two is a problem. So like for example, somebody has, imagine this is like a jar. Inside this jar, there are beads. Blue beads, red beads, and clear beads. And the red beads are more expensive than all the other ones. They're really expensive red beads. I said, I'm going to sell you this jar mixed with all these different beads, but I'm not telling you how many of each is inside here. But I'll sell it to you for $5. If there's a lot of red beads in here, this could be worth like $10. But if there's no red beads at all in the middle or something like that, it's worth like $1. But, it's your chance. It's your opportunity that you could maybe, make it. So you don't know, you're not able to analyze what you're buying completely. This is gharar, and this is forbidden. It's a forbidden type of sale. Right, so this is not allowed in Islam because someone is going to be abused in this way. It's not a fair contract because you don't know exactly what you're buying. There's a level of uncertainty there. And number 3, from the aspect of ignorance about its existence or the impossibility of its acquisition. And this relates to the obstacles to delivery. So for example, if someone says, you know what, you see that fish in the ocean there? I'm going to try and catch it for you, but you have to pay me beforehand. And if I can catch it, then you get it. But if I don't catch it, then that's too bad. Or like those little cranes in the restaurants and stuff. So the little crane comes down. You don't know if it's gonna pick it up or not. And the vast majority of time, what happens. It goes down and you're like, I got it. And it doesn't close until it starts going up, and then it closes when it's too late already, and you get absolutely nothing. So that is forbidden in Islam because there's ignorance, meaning there's uncertainty or gharar about the ability to actually get what you're supposed to try to be getting. You're buying a chance, basically. And number 4, from the aspect of its sound existence. That is, its continued existence. Does it actually exist, or is it something that could potentially not go back? So, for example, let's say you say, well, I'm going to sell you a cat, and the cat is going to be sold as is. So you buy the cat, and it's going to be delivered tomorrow, and you don't know if it's going to be alive or dead. What if the cat dies tomorrow, and you bought a dead cat? And you say, well, that's not my problem. You bought it yesterday. And I'm delivering it today, and if it dies, you got a dead cat. That's not my problem, It was yours. I just had it in my shelter for another day or whatever. So that's the problem. So these things are forbidden in Islam, although you find in today's society they're super common. They're super common because people like the chance gambling aspect of things. Yusuf. Most of the carnival games and stuff, yes, that we all play, that we all grew up playing and stuff like that, most of them are not allowed in Islam. I didn't go to the Eid picnic, I don't think. At the Eid picnic? Which Eid carnival was it? Oh, yeah, okay, yeah. So, oh, yeah, all the way down in the corner they had those games. Yeah, I didn't make it that far. I got to the edge, and I'm like, okay, whatever. We're going back. Yeah, so we need to, so whoever organizes that, they need to take some CIS classes, and someone needs to inform them, say this, we shouldn't be doing this, Yeah. If you're buying them, then yeah, because you're buying and selling things which are mystery boxes, which you don't know what's going to, if you're trying to get something out of it, you don't know if you're going to get something or lose money. The dead cat. Yeah. So as long as you clarify, so there's ways to remove the gharar in a contract. So if there's a guarantee to remove the gharar, so for example, one way is, you know what, I'm going to sell you this thing with all the beads in it and everything, and you can inspect it later. And in case there's no red beads, you get the discount back or something like that. Oh. You're talking about the jewelry and those things? Yeah, I don't know what that is. Yeah, if there's a set range of value and you pretty much know what you're getting, then it's allowed. right? If there's no set range of value, then it's not allowed. Right, so there's like what is that, Swarkofties or something like that? So yeah, that one. Right, that guy. They sell like these mystery boxes with different types of jewelry and stuff like that. You know pretty much what you're about. You're getting this much money worth of the thing, but you're getting different items. That's allowed. Mm. Yeah, I got it. I just got it for my wife because I had no idea what to get her. I'm like, here, man, you're gonna like one of these things, right? So you gotta like something out of here. Yeah, I know Chuck E. Cheese. Yeah. I don't like Chuck E. Cheese, but I know of it. Yes. Mm. So like, okay, like those ticket games and stuff like that. Yeah. So here's the thing: if you're playing like, those little roller balls, right? A skee ball, right? If you're playing for the tickets, really, and you're not playing for the game, right? Then in that case, you, there's gonna be some tickets you get, some value. It's kind of like a gray area. If you're playing for the game itself, because you just like to, get more points and you like to do the skee balling, it's like playing an arcade game. Right? You put money in there, you don't really care about the tickets. So there's many people who don't care about the tickets at all. No, because you actually want the prize. You don't enjoy seeing if you could like throw a ball inside the thing. Like, yeah, man, you know what? I threw a little ping pong ball inside of a little thing, something like that. So it's different. So it kind of depends on. There's an aspect of there's a gray area aspect to it. So there's some flexibility in that. If you're just playing for the sake of the game, it's like playing an arcade game, which may have tickets or may not have tickets. So. Yeah, what if you're trying to get something out of it, and then you're potentially not able to get that thing because you didn't get it. So, okay. All right, so that's gharar. I guess we'll stop now here. Any questions? You didn't get the what? For this week? Yeah, it'll be up tomorrow, inshallah. But I put the final up already. The final is there. The sample final is there. Read that guy's that guy who I uploaded, one of my students. He's not even a fluent English speaker. He did such an amazing job. The most improved student I've seen in my life, mashallah. Came in, couldn't speak at all. I mean, he's an imam, but I mean, couldn't speak English like properly at all. And his final speech was so good, mashallah. He delivered on the mimbar here in the masjid, with nobody watching except me and Sister Iman. But still, it's a very good speech. If you read it, he brought a basketball in. He wanted to bring a bowling ball, actually. So if you look at his speech, it was about respect of parents. He did everything, including he brought a prop in. He said he was going to bring a bowling ball. And he was going to show that, can you imagine you put this bowling ball under your shirt and you're walking around with a bowling ball the entire day. Imagine how your back would feel. Imagine how you would feel. He talked about the importance of mothers and all of that. This is what she did. She went through all of this. He did a great job, alhamdulillah. So, good role model to follow in terms of how you should make your speech. Although it could be a little bit more structured in terms of how he labeled things, and put it into one file. Don't put it into two files like he did. So you can upload. Don't complain about Canvas uploads. I uploaded one file and my second file couldn't be uploaded. Put it all in one file so you can upload it, inshallah. Okay, any questions? Questions? The final for this class should be up by Thursday, inshallah. I know. So what is the final going to be? Remember what I told you? It was going to be new issues that you've never seen before, and you have to outline them and understand what they're saying. From the same book. Right? So that's what it was going to be. I've changed the final now because that's too difficult. So, make it easier. I'm going to have you answer questions and do some outline of issues that we've already covered. So go back, double check your outlines, make sure you understand certain principles. I'm going to have you reread what we already read and explain to me what this means. I told you this already before. Hey, I told you already. That's right. It's gonna be online test, inshallah. Okay. Yeah, you can use your outlines, inshallah. Yeah. No, it's not. It's not gonna be new issues. So we canceled that part, inshallah. Okay. All right. Subhanakallahumma bihamdik. Nastaghfirukallah wa natubu ilayk. Assalamu alaikum wa rahmatullahi wa barakatuh.